Hello, everyone, and welcome to the Craft Conversations Winter Series. Today, I'm here with John Drover that will talk a little bit about intellectual property. Before we start, I'd like to do our land acknowledgement. We respectfully acknowledge the territory in which the Craft Council of Newfoundland and Labrador is located as the ancestral homeland of the Beothuk, and the island of Newfoundland as the ancestral homelands of the Mi'kmaq and Beothuk. We would also like to recognize the Inuit of Nunatsiavut and Nunatukavut and the Innu of Nitsania and their ancestors as the original people of Labrador. We strive for respectful relationships with all the people of this province as we search for collective healing and true reconciliation and honor this beautiful land together. As I said before, my name is Bruno, and I'm the Craft Council of Newfoundland and Labrador Gallery Director. And today I'm here with John Drover, who is a partner at the local law firm Roebothan McKay Marshall, and he practices personal injury civil litigation and intellectual property. John's academic accomplishment includes a gold medal for academic excellence in folklore in his undergraduate, the F.A. Aldrich Graduate Award for his graduate work in folklore, and the Bennett Jones Prize in Intellectual Property for Dalhousie Law. A tireless scholar, John went on to complete a Master of Laws in Intellectual Property while at the same time continuing to practice law. He's an active member of the arts, cultural, and heritage communities. After many years as the president of the Newfoundland Folk Art Society, John is currently chair of the board of the Artistic Fraud of Newfoundland and an executive member of the O'Brien Farm Foundation. In his spare time, John can often be found practicing yoga, online and off. So John, I'll pass the word to you, and I hope that everyone enjoyed the presentation. I will ask everyone to mute your microphones now, and if you have any questions, you can type them on the chat or wait until the end of the presentation. Thank you so much, and John, the word's with you.
Hi, everybody. I hope everybody can hear me okay. As Bruno said, my name is John. I'm a lawyer here in town, and I'm here tonight to speak to you about intellectual property, which is really, I guess, something that impacts just about everybody's life to some extent. And certainly if you're in the artistic realm, in crafting, intellectual property is really the backbone of what you do. So I would like to teach you a little bit about intellectual property. It's a fairly broad field. And maybe focus mainly on copyrights and talk a little bit about trademarks. As you can imagine, I recently completed a 2-year part-time program in intellectual property law, and to even squeeze one of those several-hour lectures into 20 minutes would be fairly impossible. So we'll just talk very generally. And I'm not a crafter. I've never really been in my life. Nobody in my family is. Like my mom, nobody knits, nobody sews, nobody makes pottery. They take some photos with their iPhones once in a while, but they get a copyright in that too. So I know really, except for the fact, that I come and see shows at the gallery and I buy local products all the time, including at the Craft Council shop and at various fairs. I know very little about the work that you all do. And you probably all do completely different things. And so if you have really any questions specific to what you're doing, don't hesitate to bring them up. So intellectual property, it's a little bit of a misnomer. When you think about property, if you think about real property, which would be, a piece of land that you might own, that you live on, or if you think about sort of personal property in the sense of, the art that I have here on my walls as physical objects, or the furniture in my place, or your car. If somebody comes and steals your real property, if somebody comes and expropriates a corner of your land and takes it for themselves and excludes you from them, then you've lost that piece of land. You somehow have to try to get it back. If someone steals your car, likewise, I mean, that car is gone. There's lots of other cars like it in the world, but as your car, it is unique. It is your car. If somebody steals your intellectual property, so you have produced, a work, whether, I don't know, it could be a painting, for example, right? If I come along and then I copy that painting, like, besides the fact that I've copied your painting, you're not actually out anything. So the intellectual property is like an intangible. You can't touch it. It's more of a sort of an idea that we have. But, society has decided that it's very important, and it's important to the functioning of our economy, and it's important for innovation in the arts and in the sciences. So society has taken steps to protect that property, or to protect those ideas or those ideals, and we call that property. We call it intellectual property, but it's not really property in the sense that we think of. So intellectual property covers sort of a lot of different fields, and I guess the best known ones, of course, would be patent, which would cover novel inventions and novel processes. And there's certainly no reason why certain crafters, or maybe any crafter, couldn't get a patent. Maybe you invent a better knitting needle or a better sewing machine, or maybe you develop a new process for making clay stronger or something like that. So being a crafter can also make you an inventor, and then you would be dealing specifically with a patent agent. But I suspect not a lot of crafters sort of get into that field of invention. Some will. There's trademarks, which everybody understands trademarks. Coca-Cola, Nike, Ford, Chevrolet, all of those brands. They own a trademark in their brand names, and possibly in some mottos and what have you. For example, Roebothan McKay Marshall, you might know us from our commercials, which says "Make the call." So if you looked on the Federal Trademark Registry for Canada, you would see that in relation to, in relation to legal services, the phrase "make the call" is owned by Roebothan McKay Marshall. So if a law firm in Vancouver, British Columbia, was advertising and saying "call us, make the call," we would have an action against them for violating our trademark, because it's our word. And then the other area is copyright, and I think we'll focus mainly on copyright tonight, because I think it's just sort of the most common thing. Not everybody owns a trademark. Not everybody gets their trademark registered. You can still have you can have a common law trademark. It doesn't have to be registered a federal registry. If you're selling under a certain brand name here, you're selling your crafts under a brand name here, then that's your brand name, and it's known, within the jurisdiction, certainly within the city, maybe on the Avalon, maybe in the entire province, if you're selling far and wide. So then if another crafter comes in and says, wow, that person's really doing really well on this particular product. I mean, apart from if they were selling completely different products, so they weren't infringing any of your other intellectual property rights, they would be interfering with your trademark rights, your common law trademark rights. But I think probably copyright is what we'll talk most about. If anyone has any particular questions about trademarks or trading under names, or how you would go about getting a trademark, I'm certainly I can answer any of those questions for you. In terms of copyright, so I think in order to really understand copyright in the modern world, you have to think about where does copyright come from? And copyright literally means the right to copy something. So if you go back, even not really that long ago, maybe the 1400s, I guess, before the invention of the printing press. If you wanted to copy a book, you know, or a scroll or a book or whatever, you would actually have to send some scribes to wherever that book was. You know, like if you're living in London and you want a copy of the Book of Kells, you would have to send scribes to Dublin to make a copy for you. So you can imagine how expensive that would be. I mean, you've got to pay those scribes. It's very skilled labor to be literate at that time. And you've got to feed them. You've got to pay their travel. So it was very, very expensive to copy anything. There's someone knocking at my door. I guarantee you it's someone campaigning, so I'm not going to answer it. Yeah, so you know, it was really a labor-intensive, expensive thing to do to get a copy of a work, of a scroll, or of anything. And then I think it was around the late 1400s. I don't know the exact date, but Gutenberg invented the printing press, right? And the whole world changed. All of a sudden, you know, you could take a book and make yourself some printing plates, and you could make as many copies of that book as you wanted. And as the technology advanced and the technology spread around Europe, and it became cheaper for people to have printing presses, practically anybody could have a printing press. Of course, you know, and once it became cheaper, then there was sort of, I guess, a push to protect works. But that's not really where the impetus for copyright law came from. The problem was it was so, anybody could publish just about anything. So the royalty of Europe, the parliaments and things, not wanting people to spread seditious ideas far and wide, wanted to clamp down on it. So they would give licenses to publishers to publish certain works, and that would be copyright. And if you didn't have, and that's where copyright comes from, it was a publisher's right. And I think 1610 was the first Copyright Act. Now the works that you make are covered by copyright. And that's a far cry really from, you know, copying books, right? So copyright over the years has really been stretched to cover many, many things: music, art, you know, visual arts, sculptures, architectural works, computer code. You know, right now genetic code is covered under the Patent Act, but there's talk that maybe genetic code would fit better under the Copyright Act. So, you know, it's a really sort of a strange sort of growth of that. And in the 1800s, I guess, you know, some countries had copyright laws and some countries didn't have copyright laws. And it was generally, you know, the European imperial powers that would have these laws, and then they would sort of export them all around the world, mostly so that they could license their own publications and make money for the home country, as opposed to any sort of altruism towards the countries that they were imposing these sort of laws on. So in the 1800s, there were a couple of treaties. One was the Paris Treaty, which covered industrial works, so industrial designs, patents and things like that, trademarks. And then in the 1880s, I think 83 was the Paris Convention, 86, there was a copyright convention, the Berne Convention. And you think like all the countries would have got on board with that, right? And the United States is the country that when you think about sort of copyright, you know, you think of the United States, the sheer amount of pop culture that the country produces, and how much it's sort of a part of all the pop culture all around the world, and how they really want to protect that. They didn't even join the Berne Convention until 1988. So I think like 102 years after it came in. And before that, they were like the most prolific copyright pirates in the world. In the 19th century, in I guess it's maybe the late 18th, early 19th century, Charles Dickens actually went on a tour of the United States by train, pleading with people to lobby their government to bring in copyright laws, because they said, well, we don't have a lot of good literature in the United States, and our people, are very illiterate. And of course, they could just take all of the English publications, Dickens and people like that who had, active copyrights at that time, and copy them to their heart's content, and make money for American publishers. So it's very interesting, that now they've become sort of the copyright police of the world. But that's a very, very, very new thing for them. So, what is a copyright, and how do you get it? And once you got one, what can you do with it? I'm just looking at your sewing pattern question. I'll get to that one in a second. So copyright, there's sort of two philosophies. One is sort of an English philosophy that what you create should be yours. You put the sweat of your brow into it, is how they would put it. Like if you go out and till a piece of land and plant some corn there and tend to it all summer, then when that corn is ripe, that should be your corn. It makes perfect sense. And it's the same sort of thing with your works, whether you're making, like I say, a quilt or pottery or what have you. That is a lot of work that you've put into that one particular piece, not to mention the investments in sort of the learning to do it, the tools, the materials, and what have you. So that would be one sort of philosophy. The other one is more French, more sort of continental Europe, and that's that, when you create a work, you're actually like taking a part of your own soul and putting it into this object. And as such, it's not just something that you've made that's separate from you. It's really a part of you. And so therefore, you should have some control over that. But either way that you get to it, it still involves the protection of a work. So your works would be considered artistic works. Like I said, there are many different kinds of works under the Copyright Act: musical works, cinematography, photography, and artistic works. And each of them might have a little bit of sort of nuances about the protections and certain dates that different treaties have come into place. But an artistic work would include paintings, drawings, maps, charts, plans. And I think the plans, in terms of the question that was in the chat about, a sewing pattern is a plan. So, you can protect that plan. But in the world of fashion, the clothes that are made, and this, I don't think you're talking about clothes, you're probably talking about a quilt, but it might apply in the same way. It would be a copyright infringement for me to copy your pattern, but it would not be a copyright infringement for me to go to a fashion show and see somebody wearing that and make as close of a replica as I can make from a visual inspection. So it's a bit of a strange thing. I think it's probably, in terms of fashion, it's probably because fashion is so fleeting. It's meant to be one season and then it's gone. So, what's the point of, by the time somebody sees it on the runway and makes their own patterns, the other company's already way ahead of them, and in 3 months it's all going to change anyway. So who needs to protect all this stuff? So I think plans would fall into that, and artistic work would also include photographs, engravings, sculptures, works of artistic craftsmanship, which I think a lot of your works would fall into, architectural works, and compilations of those works. So in order to get a copyright, I got a little iPad here, so I got some notes on here. So if I'm looking down, I'm not paying attention to you. So in Canada, you get a copyright in every original literary, dramatic, musical, and artistic work. And the only thing you have to do is make it a physical manifestation. So there's a thing in, I guess, copyright that people talk about, the idea expression dichotomy. Like you can't have a copyright in an idea. You can only have a copyright in the physical manifestation of that idea. So for example, I don't know, if there was, if there's sort of a local story going around, right? And everybody's talking about it. I could sit down and write a book based on that story. Someone else might, I don't know, someone else might craft little felt sculptures depicting characters in that story. Somebody else could make a painting or do an engraving. The ideas behind that story, you can't own an idea. You can only own an expression of that idea. So the only two requirements to get a copyright is that something is original, and original, of course, is not defined anywhere in the Act, so it's been left up to the courts to define what original is. And all the courts have said is that it has to show at least a minimum amount of skill and judgment, and it's not just copying. So that is a very, very low bar to get a copyright. Really, if you write a note to one of your roommates or your wife or husband and stick it to the fridge, you own a copyright. You own a copyright in that note. I mean, what are you going to do with the copyright in that note? Nothing. But the copyright exists in it. And like I said, the copyright is a right to copy. So that means it's a right to sort of produce or reproduce the work, or any substantial part of it. So you don't have to copy an entire work. If you copy a paragraph from a book and claim it as your own, you've violated copyright, possibly even just a few sentences, depending sort of on the situation. And it's also for artistic works, and this one is one, like I said, copyright acts are updated all the time, depending on sort of where the world is headed in that way, and through international agreements. So if you, for any of your artistic works produced after 1988, what year was it? Yeah, June 7th, 1988. So any of your works produced after June 7th, 1988 cannot be shown in a public exhibition without your permission. That is considered a violation of copyright. Anything you created before then can go into a public exhibition without your permission. And other than that, like I said, it's mostly to do with copying, but it also deals with translations. If you write a book in English, it's your right to translate it into, it's your right to translate it then into German or French or any other language. Or if you wrote a book, it's your right to create, to make a movie based on that. If you're a sculptor and you've made like a collection of little characters, you can reproduce them then in an animated series or write a book about them, and so it's not just copying, it's also translating and sort of making other works that are based on those previous works. So I think I hope that answers Jessica's question. How do you obtain a copyright? You obtain a copyright just by making something. Like you get the copyright. So what can you do with your copyright, I guess, is the big question. For artists, public exhibition is the thing, maybe some of you have had shows at Craft Gallery. I'm sure the Craft Gallery has sort of waivers where you say, okay, it's okay for you to show this work. There is a copyright. I'll answer that to Jessica again. And she said in the chat that she wasn't sure if she had to physically apply for something. No, you don't. Like, to get a patent, you have to like go through a whole process. Same thing with a trademark. You have to go through a whole process. Copyright, all you have to do is make something, and it lasts until 50 years after the end of the year that you die. So if you were to die this year, it wouldn't be until 2071 that your copyright expires, right? That's a really long time. So, you know, and in terms of, I don't know, in terms of estate planning, I never see anybody, even artists, you know, maybe writers or something, but nobody ever thinks about their copyright. Like, who am I going to leave my copyright to? Because your copyright is good for 50 years. And in fact, if you sold your copyright, if you signed it over to somebody, even 25 years after your death, despite the assignment, it reverts back to your estate. So there was a very interesting sort of series of cases out of Prince Edward Island dealing with Lucy Maud Montgomery's estate. That was her name, right? She wrote Anne of Green Gables. You know, so she had assigned that copyright, I guess, to her publisher at some point, and her publisher had licensed crafters in Prince Edward Island to make Anne of Green Gables licensed crafts, right? I mean, great idea. George Lucas did it with Star Wars. He probably made more money off the action figures than he did off the movie. But after 25 years after she died, it reverted back to her estate. And so then, you know, the people who really had nothing to do with her producing that work, I mean, 25 years after she was dead, it was probably her grandchildren or even her great-grandchildren, decided that they were going to go back to the crafters, you know, and squeeze a little bit of money out of them because they had a very successful craft business going based on Anne of Green Gables, which they were licensed to produce over the years. So, you know, this is an interesting thing to think about. What's going to happen to copyright? I assume all of you are crafters and that you produce things all the time, and they, you know, they all have a copyright in them that right now is going to run until 50 years after your death. In the United States, they change it if it's, you know, if it's a company that owns the copyright. In Canada, it just lasts from 50 years from when it was made. In the United States, they have it's officially called the Sonny Bono Copyright Extension Act. It's sometimes sort of derisively referred to as the Mickey Mouse Copyright Act, because the copyright on Mickey Mouse was about to expire in the 90s. And once that expired, I mean, if China wanted to open 10 million Disneylands and not give a cent to the United States, they could have totally done it. They could have made Mickey Mouse movies, sold Mickey Mouse t-shirts, did whatever they want. No consequences, because the copyright was going to be up. So in the United States now, it's the end of the author's life plus 70 years. And it's like 95 years for a corporation. And there's another provision that makes it like 120 years. And that was to extend protection for Mickey Mouse into the 2040s. And I would imagine Disney is going to be just as big a player on the world stage in the 2040s as they are today. So it'll be interesting to see what the United States does with that. I mean, it's a very intellectual or international sort of thing, copyright. Like, you don't only get a copyright in Canada, you get a copyright in every Berne Convention country in the whole world. Your copyright is good all over the world. I think there might be 15 or 20 countries that are not signatories, you know, some war-torn countries, some communist countries, you know, smaller countries, Angola, Cuba, places like that. But for the most part, you know, you've probably got 150 countries or more around the world where every single thing that you produce through your work is copyright protected. So, you know, the question is, what can you do with it? I mean, I'm not big in the craft world here, so I don't know if there's, you know, if there's a lot of people stealing one another's sort of copying each other's things. I don't know. But Pablo, I think it was Picasso who said, like a good artist copies a great artist steals, something like that. And certainly I was very involved with the Folk Art Society. So, a lot of like storytelling and folk music and things like that. And for the most part, it's a very sharing community because a lot of the stuff is like public domain. So after a copyright's over, it's called public domain. So lots of old songs, you can copy them all you want. You still get a copyright, when you then perform that song and record it, you get a copyright to that particular recording. Just because the song is 500 years old doesn't mean that I can take Matthew Burns' recording of it and go copy that and give it out to my friends or post it on the internet, right? But I can certainly take the words and the melody to it and make my own recording. So I think someone must have a question by now. It's been talking forever. I mean, I could talk all night, no question.
Besides the questions that popped up, one thing that you mentioned that is very interesting is that, like, for you to get a copyright, you just need to make it. How do you go about proving that you were the first person that made that?
How is it that you would go about it? Well, that's where the copyright registry can play a role. So Canada has an intellectual property office, the Canadian Intellectual Property Office, and that's where the patent registry is and the trademark registry. In order to register something on the patent or the trademark registry, you have to be an agent. So you have to do a course. For trademarks, you need at least 2 years, like hands-on experience working in a place where they do trademarks. You write an exam, and then you're a trademark agent. And then you work with clients to walk them through the process to get a trademark. Patents is an even more in-depth process because you're dealing with, inventions, and you're dealing with molecules, drugs, and things like that, right? So that's pretty specialized engineers, PhDs, people like that. But for the copyright registry, anybody can sign up for free to access the copyright registry to register things. Anybody can search any of the registries. You can all search the patent registry online, the trademark registry to see who owns what, and you can search the copyright registry. And so you can just sign up for free, and then if when you create something, you can register a copyright in that item. And then, if there was any dispute about what came first, then that would be evidence, of when yours was created. But in general, I mean, it's just really extrinsic evidence, you know what I mean? Like, oh yeah, I saw Bruno's recent textile art, or like 5 years ago, I remember going over to Bruno's house and he showed me this thing that he made, you know what I mean? You could call me in as a witness, but right, there is no real way to prove what came first, except the way that lawyers try to prove just about anything. Normally it's pretty clear, and copyright does allow for simultaneous creation. So it does allow for like two people in different places to create exactly the same thing without, another thing. In order to prove infringement, you would have to prove access. You'd have to prove that somehow you got access to this thing. Pretty easy for, things that are on the internet or movies or radio, music or things like that. But if it's a unique thing, that you have kind of guarded, it's in your studio and nobody's really seen it except, this other crafter that dropped by for a cup of tea one night, and all of a sudden now they've made the exact same thing,
Mm-hmm. There is a question from Jen. Sorry.
Yeah, go ahead. Physical manifestation.
Yeah.
How does it work in the digital world? It's not really I shouldn't call it physical manifestation. The word is an expression. So it has to be an expression of the idea. It has to be fixated. That's the actual word, to fixate it. So you can fixate something on the internet or digital works. Somewhere in the world, there's a bunch of switches that are at ones and zeros to produce that work. So there is something physical supporting that, even though it's digital. If it's online, it's been published. Online is considered publication. I think showing anything in public, if it's a physical thing, would be considered publication.
Does that?
But that is also your right. So if it's an unpublished work, I mean, it's also, besides your right to publish something and copy it as many times as you want, you also have the right of first publication. So if you wrote a novel, even if it was a digital novel and you hadn't published it on the internet, but it was on your computer, you have a copyright in that for 50 years. And the copyright also is the right to publish. So after you die, only the copyright owner after your death can publish something like that. If you produce things and somebody is going to do an exhibit of your work posthumously, and all your work's been created after June 7th, 1988, the exhibitor cannot exhibit those works without permission from the copyright owner. And so, if you don't really deal with that in your will, who knows who it's going to go to and what, whether they'll manage it for you. There's licensing. I mean, if you own a copyright, you can license it. For example, I don't know, you're making a craft. Let's say you're a potter and you make a nice teacup, and then Wedgwood, if there's still a thing, comes in and sees your teacup, and they're like, "We love your teacup. We'd like to make like 10,000 of them," right? You could license it to them. You could have an exclusive license so that only they can do it. You can have a sole exclusive license, which means not even the copyright owner is allowed to do anything with the copyright. You can have like a non-exclusive license, so you can license to multiple different companies. Should you label something you've written or created as being copyright? Is not required. You don't have to like put that C with a little circle on it, like you get the copyright, but you could put it on there as proof of copyright. There are also other, certainly, I mean, it's interesting that you brought up the digital world. There are certain standard licenses available online. So I don't know if a lot of you have heard of an organization called Creative Commons. They're sort of trying to, I guess they're trying to open up knowledge and have more sharing of information. So they have sort of ready to go digital licenses where you can kind of click a bunch of boxes. So you'll let others, others can use your work, but not for commercial purposes and only if they associate you with it. And another thing, I completely forgot this one under copyright, and no one really ever talks about it much, is moral rights. So besides your copyright, when you fix a work, when you make a work a thing, you take it from the idea into a thing, not only do you get a copyright, but you also in Canada get moral rights. And moral rights involve two things. One is the right to be associated with your work. So, that this particular felt sculpture is by Janet Peters. She does felt sculpture, I believe, doesn't she? Am I right?
Yeah.
Yeah. So, so that is associated with her and her name is not removed from it. And another one is the right to the integrity of your work. So if I buy one of Janet's sculptures and I don't really like the way the cat looks, so I get out my little felting hook and make the cat the way I want it to look. Just because I own the physical thing, Janet Peters still owns the moral rights. And if she knew that I had altered her work in any way like that, she could take me to court and sue me for infringing her moral rights. And probably the craziest case, I guess, in Canada, Supreme Court case on moral rights. If you've ever been to the Eaton Centre in Toronto, there's a flock of like Canadian geese, like bronze Canadian geese flying through the atrium. So one year the Eaton Center decided to decorate the geese for Christmas, and they put big red bows around all their necks. And the artist lost his mind and sued them. And got an injunction forcing them to take the ribbons off, and then got, I think, a fairly substantial sort of cash award. It went all the way to the Supreme Court of Canada just for putting like ribbons around the neck of a sculpture, a public sculpture, you know. So if you own any original works and you decorate them for Christmas, you're probably infringing someone's moral rights. And if the crafter came to your house and saw what you had done to their particular work, and it, you know, and it's kind of like a defamation thing, like it has to hurt the artist's reputation. You know, these are just strange. It's a strange sort of world that we live in when it comes to copyright law, because we deal with it like all the time.
So there is another question, John. Margaret Walsh asked, could you comment on the copyright of online instructional art videos? How does that work?
You would own the copyright in them unless you have signed on to, well, that's not necessarily true. Okay, let me start over. The photographer owns the copyright in a photo, not the person. Like, the person in the photo has no right to the photo. That would be the same thing. So if I came over to your house and filmed you giving an online art tutorial, I own the copyright because I'm the one that fixed it. Like, you're talking about you know, you're talking about the work and how to do it. You know, you're giving the instruction. There's no copyright in the spoken word. There's only a copyright in when you fix something. So the person who fixes it gets the copyright, absent an agreement to the contrary. So if you're filming yourself, no problem. If someone else is filming you, you could actually run into a problem in that they own the copyright. Now, when you post it online, if you're posting it to Facebook or Twitter or YouTube or what have you, I mean, if you're posting to one of those platforms, you know, that big long agreement that just scrolls forever, and you're like, scroll, click. You didn't read it. I didn't read it. Nobody reads it. But you're responsible for it because you clicked I agree, and they probably made you click I agree twice. So somewhere in that is very likely some statement about copyright and who owns what. And it's probably that you still own the copyright, but you are licensing it to YouTube or Facebook or what have you, but they can, you know, do certain things with it depending on the platform. So yeah, so, you know, so if somebody comes over to your house to film you doing an art video, you know, you might be wise just to at least have an oral agreement to say, oh, hey, funny, I did this online chat a couple of weeks ago, and they were talking about copyright. So you're filming, but I own the copyright, right? And they'll say, yeah, right. So an oral agreement is as good as anything else. It's better than, well, it's not as good as anything else. It's better than nothing.
Does that answer your question, Margaret?
Do you want to turn on the mic and talk to me? We might get through it quicker. Oh, no, now we lost our video.
She will be coming in, and I think
she'll come back.
Stephanie Berry just joined us. Welcome, Stephanie. Margaret, you there?
Yes, I am.
Okay.
Oh, hi.
Oh, I'm back there.
There
the question
you go.
The question I was asking about had to do with more of instructional videos that you see online. If another instructor can avail of any part of those videos.
Can you avail? Well, you know, there is an exception in there's a few exceptions in the Copyright Act. One of them is education. Private study, research, education. There's some special ones for museums and archives. So if it's purely educational, you might fit into it. They have a copyright over the video, but they don't have they don't have any copyright over the techniques. You know what I mean? They'd have a copyright over the script that that they're sort of talking. Like if you're painting like Bob Ross and you're using all of an entire script from a Bob Ross video, there would be a copyright in that.
Yes,
if you're not.
Can I just tell you a situation?
Yeah, absolutely.
That in a group that I'm involved in, I'm on the executive. We requested of a UK artist to use part of her instructional video in our meeting, and she agreed. But she said normally, which is something you would do anyway if you wanted to use anything, is ask the permission of the creator. But she said normally there is a booking fee. And I'm not sure if those kinds of things are in effect in Canada, or are the rules international?
No, she's giving you that's basically a license, right? And so, like I said, you get a copyright. We're a member of a Berne Treaty nation,
yes,
and the UK is part of the Berne Treaty. So copyrights from all those countries are. Like there's a minimum. It's not that everybody's treated equally, but everybody has to be treated at a bare minimum. So everybody has to have their copyright. It has to be protected for a minimum of life plus 50 years, and there's some specifics around licensing and assignments. So yes, if you had taken that video and used it and she'd found out about it, she could have sued for copyright infringement.
She gave permission to use 10 minutes of it.
Yeah.
Which,
that's she's just giving you a limited one-time license, but she gave it to you for free, right? You didn't end up having to pay for it.
And suppose that somebody decided to take that video and use it in a class that suppose it was another instructor using that video, even for 10 minutes. It would.
Yeah, like I said, there is an educational education exemption under the Copyright Act, and in recent years the Supreme Court of Canada has begun to really broaden that out to allow more things to fall within education. But then it's going to come down to if you're an educational institute, you would definitely fall under it. If you're an organization and part of your mandate is education in some respect, like the Craft Council, for example, if part of their mandate is education of the public about crafting techniques, and you use the video, you might get away with it. If you're John Drover and I'm running my private business is running a class out of the Lantern, and I'm charging $500 a head, and everyone comes in and watches her video to learn, that's probably crossing the line. So it really depends on the context. There is an exception that just says educational exception, but if the law was black and white, there'd be no lawyers. So the question is, what is an educational context? And some of them, like I said, are very clear. MUN is an educational institute. Some of them are very clearly not an individual whose business is, making money off of education in that way. Probably not so much, particularly if it's just a one-off thing and not part of any certification program or anything. Okay,
thank you. That answered my question. And you mentioned that the copyright belonged to the photographer or the person doing the video in this case. But if that person, if that technician was being, or that artist was being hired to photograph or to do a video,
that's right. Then it's a work for hire, and the person paying the bill owns it.
Yes,
Yeah.
answered. Yeah. Okay, thank you.
Do we have any other questions?
So just be careful when it's your friends helping you out.
Yes.
Otherwise, you're fine.
Beware. Beware. Thank
you. Beware of your friends.
Do we have any other questions? No.
Seems not.
Well, I would like John for give you the presentation tonight, and I also would like to thank everyone that took their time to come. For those who came late to the meeting because of time difference or because of any issues, the video is being recorded and will be posted on the YouTube channel of the council, which by getting the tickets for this, you gave us the right to record that and post it online.
Yeah, I think that's almost an expectation. And of course, it's like as we say in the commercial, it's free to make the call. So if you have a specific question about trade names or common law trademarks or copyrights, or you're looking to maybe license something from someone or to something, call Roebothan McKay, Marshall, ask for me. I'd be more than happy to answer your questions.
So thanks everyone. Hope you have a great evening. Craft Conversations is still gonna go on until the end of March, every second Wednesday. So make sure that you sign up for the next sessions. We have several different themes being explored from now until the end of March. Get on our Facebook and check out the schedule for that. Thank you so much, everyone, and have a good night.